Hello and welcome to new lecture in the module of Fight Against Corruption, which I, Elnur Musayev, am teaching at Baku State University for a postgraduate course as a lecturer of Criminal Law and Criminology department. This is ninth in a series of lectures entitled Incrimination of Corruption in Private Sector, as well as other corruption offences. I'll be speaking about this issue of fight against corruption in a wide sense, in a general framework, and then about its specificity in Azerbaijan. So let us get started with it. As I'm teaching this for the spring 2020 term, I would like to confirm my message to all my listeners, my students and other listeners. Please stay at home, be optimistic, and don't waste your time. And this message is in the colors of our national flag. I hope I will inspire you to, I will inspire and generate your interest in this subject, and you will be continuing to listen to my lectures, and you may even subscribe to my channel for future lectures. And instead of just doing something else, you can benefit from this channel and my lectures. So let me speak about the content. As usual in our previous lectures, I'll speak about the topic in general. I will I will locate it in the wider framework, and then we will go through the previous lectures, some highlighting some important issues which will certainly have bearing upon our today's conversation. And from that on, we will switch to specific offences which are provided by the international instruments. We will look at their requirements, dissect them, and we will look at the provisions of national legislation. Where possible, we will collate these requirements, find out similarities, different points, even between specific offences in national legislation. So off we go. We spoke about the position of the position of Azerbaijan in the fight against corruption. As many countries of the world, Azerbaijan took this pattern of fight against corruption from the pattern set by the United Nations Convention Against Corruption, which is dealing with this issue in under four broad topics in four different areas, which are prevention of corruption, incrimination of corruption, legal cooperation to tackle corruption, and recovery of assets which are gained as a result of corrupted activities. Our today's lecture is in the area of incrimination of corruption, which means that we will be talking about corruption as offense and not just wrongdoing or not some kind of irregularity. We will speak about incrimination, and the position in this area is that there's no single definition of corruption. Instead, international institutions have developed this common position, and governments joined this too, that since it's not possible to develop single definition of corruption, they will just set a list of offenses, describe them, and countries will join their efforts in criminalizing them in similar manner. By saying criminalizing, I mean that they will describe them in their national legislation and try to develop these uniform patterns of their implementation. What's important in this area is that there is a principle of criminal law on certainty that norms of criminal law must be certain, and it means that the these crimes have to be formulated in a very specific manner. However, we know that corruption is a dynamic phenomenon, and it develops with time, with criminals getting notoriously witter and using more and more sophisticated mechanisms, complex tools and vehicles to hide their illegal gains and to hide their illegal activities. Therefore, fight against corruption must be on the balance. It must balance between this principle of certainty of criminal law and the attempt to express the terms of references for this fight, for this war against corruption, in such a way that it's not limited to specific certain types of activities, to narrow circle of activities. Rather, the countries are called upon to develop their legislation in such a mode which will allow its authorities, especially judicial authorities, to interpret these terms in a wider way, in an inclusive mode, so that corrupted officials, whether in private sector or public sector, they don't get away with their illegal behavior. And it was not by chance that I mentioned private and public sector, because it is the position accepted internationally that corruption in private sector is as dangerous as in the public sector, because in many countries private sector is dominating the economic field, and in terms of production, it's having absolute majority in the majority of weight in the economy of a state. It's a common situation right now. So this fight against corruption in the domain of criminal law, it must not be constrained. It shall not refer to exhaustive lists, rather the lists which are used in interpreting and in expressing, formulating these corruption offences. They must not be exhaustive, they must be wide. And in our previous lectures, we spoke about specific concepts which are crucial and important. We spoke about them in the context of public sector bribery, but they will be important for our today's conversation as well. These concepts are offer promise, acceptance of offer and promise, acceptance and solicitation, and of course giving. And all these terms, under the current understanding and current conceptualizing of corruption, they are equal in their effect. That means whether a bribe, whether undue advantage is offered or promised or given, it doesn't matter in the eyes of the law. The law looks similar to this type of behavior, and it provides similar sanctions for it. And it's explained by the philosophy of a fight against corruption, that even a slight chance to engage in illegal corrupt activity is already danger, and it must be suppressed and it must be fought. We spoke is also about this concept of third-party benefit, which is crucial in practical terms. As I explained to you, the corrupted officials, they're getting more witty, they're getting smarter, and they are smart anyway, but they're getting even more smart and tricky. They use these sophisticated mechanisms. So therefore, it is quite common that corrupted officials are not getting benefit for themselves, but rather they hide it under the title of some third party, whether it's their relatives, their friends, their acquaintances whom they can trust. some obscure financial arrangements which allow them to hide their beneficial ownership, as well as legal persons or political parties. So this concept is crucial in criminalization of corruption. Also, I mentioned to you the undue advantage concept, i.e., anything which puts undue advantage as a subject matter of a bribe, which is, in other words, it's a bribe itself, which is everything, which could be everything, that puts the perpetrator or perpetrators in a better position than they used to be before commission of this corruption act. And in description of such in some criminal offences such as embezzlement, for example, the international conventions and national legislation, they're both using the concept of property as well, which is also described as anything which is material or immaterial, corporeal or incorporeal, tangible or intangible, and it could be also documents which are supporting the legal title to property. And when I say this immaterial, I mean anything which is not even everything which even cannot be expressed in terms of monetary value. So we spoke about the incrimination of offences and mostly concentrated in this upper part of the list. But before continuing with it, I shall mention to you that remind you that Azerbaijan is member to two important international instruments in this field, which is United Nations Convention Against Corruption and European Criminal Law Convention Against Corruption. So Azerbaijan not only following this United Nations instrument, but it also follows the requirements of the European Convention, which, by the way, have a few non-European members too, parties to it. And in implementing this European Convention, Azerbaijan is actually sometimes going behind the requirements and doing something a little bit more than what is indicated in the provisions of the ANCAC. Here and on the screen you can see the overall set of offences. We spoke to you mostly and we looked at the offences in the domain of public sector, but there are also offences in the area of private sector, as you can see here, and some specific offences of concealment and obstruction of justice, which we are going to look at today. In national legislation of Azerbaijan, as you can see from the title of the slide, of domestic incrimination of corruption, the corruption offences are mostly registered with Chapter 30, which is entitled this way: the offences of corruption and other offences against interest of service. This chapter includes such offences as active and passive bribery, trade in influence, and abuse of office. We also spoke about Section 179, embezzlement and diversion, which happens to be in another chapter of the Penal Code, which is about crimes against property. And let me remind you here once again that in Azerbaijan, only if a crime is included or described in the special part of the Penal Code, it is criminalized, it's considered a crime, and appropriate sanctions are applied to it. Unlike other countries where there could be numerous other statutes or regulations or ordinances by virtue of which certain action can be criminalized, no, in Azerbaijan, these actions, they have to be included within the penal code. So we're strictly following the requirements of the continental legal system, or otherwise called civil law systems. The offences which are covered by this appropriate articles of United Nations Convention Against Corruption under the title of obstruction of justice. They are covered by virtue of several sections of the Penal Code, as you can see on the screen. Section 287, for example, encroaching upon life of investigative or judicial official, or section 288 on the application of threat or violence in connection with adjudication or investigation, or section 299 on perjury and witness tampering. And in the titles of these sections, I try to preserve this national terminology. And as you know, according to a legal tradition of a country, there's certain way of expressing the same ideas in different countries. But essentially, I put these articles on these sections on the screen in order to show you how the legislation of Azerbaijan is covering this offense of obstruction of justice. There's also a section in the Penal Code 194, as you can see, which is entitled concealment, and it corresponds with the similarly entitled article of the United Nations Convention Against Corruption. And in the end, I will speak about very shortly about this concept of in the exercise of his or her duty. I told you previously that this is a kind of concept which allows to demonstrate that this any kind of offense can be committed by a public official. Of course, it does not apply to all the crimes in the penal code, but there are many crimes which, apart from being committed by just ordinary people, they can also be committed by public officials. And usually this is considered the aggravated type of that specific offense. As an example, I will be speaking about this offense described in section 178.2 and most aggravated forms of it, in which is entitled fraud by an official. Let us speak first about this private sector corruption. In the United Nations Convention, it's mostly about the offenses of bribery and embezzlement. And we also will speak shortly about foreign public official bribery and international public official bribery. Let us first revise the provisions which I spoke to you about in our previous lectures. The definition of public official, as you see from the screen, it's described to the reference to mode of occupation, term of reference, financial arrangements, hierarchy, the nature of function, as well as mentioning in national legislation. So it's really unimportant. The United Nations Convention takes this broad position and broad view on the definition of public official, whether the public official is appointed or elected, paid or unpaid, whether he works temporary or on a permanent basis. And in our legislation, which is in note to section 308, which is an integral part of our penal legislation, similarly, the definition of public official is through the reference to such criteria as mode of occupation, representation by special kind of authority vested in a person. The legislation refers to specific military personnel and civil servants, as well as political candidates. And through this also mentioned, this note also mentions there's some institutional arrangements and specific functions, the implementation of which, even without employment, makes the person being considered allows to consider that person as an official, public official. So this is the position which I told you. Usually, anyone in the private sector, according to the provisions of the Penal Code, they can be prosecuted for corruption offences. A Constitutional Court's decision, Constitutional Court's plenary board issued decision which somehow limits it in certain way, but not dramatically, because in any case, whichever action is really important, which is really falling into the under the effect of anti-corruption provisions, these are actions which have legal significance, legal importance, and they usually generate legal relations, i.e., relations which are regulated by some sort of legislation. Let us look now at domestic foreign at foreign public official regulation at UNCAC and domestic level. United Nations Convention against Corruption, it defines foreign public official according to the office, whether it's executive, legislative, or judicial, administrative, mode of occupation, and whether it's mentioned in the national regulation of that specific country. As you can see, the definition is here. Any person holding a legislative, executive, administrative, or judicial office of a foreign country, whether appointed or elected, or any person exercising a public function for a foreign country, including for a public agency or foreign public enterprise. In domestic legislation, the position is reflected in note to Section 308 of the Penal Code. It refers to foreign public officials, including elected foreign officials. The definition is quite wide and appears to be in line with the requirements of the United Nations Convention. When we speak about international public officials, again, the international instrument describes this concept as international civil servant or any person who is authorized by such an organization. In Azerbaijan, it's a reference to through the reference to note to Section 308 of the Penal Code. The legislation describes them as officials of international organizations, which is rather wide enough. And going further, in line with the provisions of European Criminal Law Convention on Corruption, the legislation of Azerbaijan criminalizes members of international parliamentary assemblies, judges and officials of international courts, and also Azerbaijan criminalizes the corruption by arbiters, which is an additional protocol to European Criminal Law Convention on Corruption. Again, by virtue of this note to Section 308. So much about the corruption in private sector. As I told you, Azerbaijan doesn't have separate norms treating separately corruption in private and public sector. This is in a sense a bit complex, in a bit much simpler arrangements, which has its own virtues and deficiencies, but it's operating in this country. It has been operating for many years, and it is settled in legal traditions of this country. So I'm not going to go through these through these provisions of active and passive bribery or embezzlement, because they are the same, and the concepts are the same, including offer, promise, acceptance of offer and promise, and solicitation, third party benefit, undue advantage, they are the same. So there's only one norms, there's only one section in the penal code, for example, which is criminalizing active bribery in both private and public sector. That's why we're moving now to the offense of concealment, which is specifically included, provided in the among the offenses listed in the United Nations Convention Against Corruption. According to UNCAC, this crime is it's laid out as when committed intentionally after the commission of any of the offenses, and here it's a reference to these specific offenses mentioned in the United Nations Convention, without having participated in such offenses, the concealment or continued retention of property when the person involved knows that such property is the result of any of the offenses established in accordance with this convention. In national legislation, there is a specific provision, as I mentioned to you earlier. It's section 194 of the Penal Code, which reads, acquiring, owning, or using of property without previous promise to do so, with the knowledge that it is proceeds of crime, or administering such property with a view to conceal its illegal origin. Again, we have to take into account legal traditions of the country in expressing the same idea but in a different mode. Here why we have this different type of acquiring, owning, and using, as you can see, administering this concept. They refer to the civil law right describing the ownership of a property according to civil law provision. Owning property means to be able to own, use, and dispose of the property. So these terms are specifically referring to these three types of actions to encompass the full concept of ownership according to legislation of Azerbaijan. So let us dissect this provision. Let us dissect this section 194 on concealment. Mens rea, as usual for all types of corruption offences, is intention, direct intent, and no other forms of guilt is acceptable for corruption offences. Actus reus, perpetrator, it could be anyone, including public official. Modus operandi, United Nations Convention Against Corruption refers to a continued retention, which means that the property is at the disposal of the person for continuous mode for some time, and it covers different types of or different concepts of owning that property. In our legislation in the Penal Code of Azerbaijan, it is expressed through these actions, through these active elements of acquiring, owning, or using of property, plus concealment. In the United Nations Convention, there's a term of concealing the ownership in Azerbaijan, as you saw it in the previous slide. The legislation refers to administering it in such a way that it conceals the illegal origin of the property. Incentive doesn't need to be shown here, so it alleviates the position of the investigative and prosecutorial authorities they don't need to show that actually the person is getting profit from that, because if there could be a situation where it's difficult to do that, and in case if the person can do that, if the investigation or prosecution can show that there is some incentive issues involved here, they can go after perpetrators with a harsher under harsher indictment articles for money laundering and other corruption offences, of which we will speak later on in our subsequent lectures. Beneficiary also doesn't need to be shown, and condition and necessary condition, which is the subjective element, and practitioners would know that it's very difficult to establish this subjective element of knowledge, that the person was aware that such property is obtained as a result of commission of offense. So there must be the knowledge must be demonstrated in accordance with the strict requirements and strict standards of criminal law beyond reasonable doubt. Otherwise, no conviction will stand. Let us see where this crime stands among the classification of crimes, which became tradition in our lectures as well. Let me remind you that there are 4 different categories of crimes according to the level of their gravity, and they are differentiated according to the sanctions, specifically the number of years. So crimes of not big public danger are the ones which are sanctioned with some alternative sanctions such as fine or anything else, or public works, or imprisonment up to 2 years. The next category, more grave crime, the graver crime of less serious offences. It is sanctioned with imprisonment up to 7 years. Next one is serious crime with the imprisonment up to 12 years. And anything above 12 years, including the capital punishment in this country, the highest punishment in this country of life imprisonment, is considered especially serious crime. And usually, as I told you, until very recently, corruption offences were in this range, but very recently, in line with the humanitarian, in view of the humanitarian considerations, sanctions for very small amount of corruption offences were reduced, and they fit into this category, only the small part of it. And there were some great cases, especially cases of embezzlement in large amounts, which necessitated that some forms of corruption offences are moved into this category as well. So very few corruption crimes are now considered as especially serious crimes, and they are subject to sanctions of imprisonment more than 12 years. And this classification of crimes has certain bearings on the statute of limitation terms, as well as the terms of pre-trial investigation and custody. So where this offense of concealment stands in this category, there are actually 3 types of concealment. The basic form is within the range, it's considered as a crime of not big public danger, i.e. it's punished with alternative sanctions and imprisonment up to 2 years. The next one, when it's committed in large amount, usually you can consult specifically in order to find out what the large amount is, but usually it's above 5,000. I might be wrong. Please consult this this provision. And finally, this gravest form, which is which is if the offense is conducted by the premeditated conspiracy or organized group, when there's like a fixed set of people who have these links between them, when the links are not very strong, simply speaking, it's a premeditated conspiracy. When it's operating for a long time with appropriate hierarchy among the members and functions assigned, then it's an organized group. When concealment appears in this form committed by organized group, then it's a graver form of concealment. Also, the concealment committed by public official or in great amount. These last two categories, these last two types of concealment, they are considered less serious crimes, and they're punished with the imprisonment up to 7 years. And of course, the sanction for this middle one is some lower than for this one at the top, in line with the requirements of the United Nations Convention on Sanctions, that they must be dissuasive, proportionate, and adequate. So much so about the offense of concealment of 299. We have this additional element of promise, offering, or giving. We have this one, and force, threats, or intimidation. And in the second category, because all the people who are mentioned here are justice or law enforcement officials, or speaking in Azerbaijani context, judge, prosecutor, investigator, inquirer, forensic expert, court martial, or their close relatives. Okay, they are who? They are public officials. So anything of any attempt or any action of giving them undue advantage would be classified as a case of bribery. Okay, and this was the similar position. A similar position was expressed. I told you when I described to you this offense of manipulation of a sports event, the very important provision of Azerbaijani legislation, which is which is responding to corruption in sports, very significant topics nowadays. And in that sector, it describes the subordination of people involved in this sector in order to manipulate sport. But specifically, it also mentions that if people involved in these illegal activities are public officials, then the case, it has to be qualified under the different section of the penal code, i.e. Sections on bribery, active or passive one. That's why we don't have this additional mode of committing crime in the form of subornation or giving or promising or offering of undue advantage. The next one, the next offense, I'm speaking about the final category of offenses, corruption offenses in Azerbaijan. As I told you in the beginning of our lecture, mostly the corruption offenses in our legislation, they are concentrated in section 30, entitled Corruption Offences and of Other Offences Against Interest of Service, whether private or public, in Azerbaijan. But I also told you that this chapter doesn't cover all the corruption offences. There is a concept of acting within the framework of his or her duty, which is indicated in a number of offenses, in a number of sections of the penal code, describing different types of offenses. And usually commission of a crime by a public official is considered as an aggravated form. So it usually comes in the second or third or fourth subsection. So if an offense if usually is committed by ordinary people, then it's considered a basic form of this offense. But if it's committed by a public official, the same actions, if they're committed by public officials or officials in even in private sector, it is considered that the crime was committed in an aggravated form. An example of this, I'm not going to cover all these offenses. I will give you one very typical one, widespread, let's say so. Not that all officials are fraudsters in this country, but it's rather spread it has certain weight among the crimes committed in Azerbaijan. It's section 178 of fraud or otherwise swindling. It can be translated this way. Mens rea, by the way, fraud or swindling is considered also the same category as embezzlement and misappropriation and diversion. It's a type of a crime against property. Mens rea here is intentional. Actus reus, as I told you, a basic form of this offense described in subsection 178.1 is a typical basic form of fraud. It could be committed by anyone, but if the same crime is committed by a public official, it's automatically considered a graver form of fraud, which is 178.2. So perpetrator, for the sake of our, for the purposes of our discussion, is public official. Modus operandi, it's getting hold of property by means of abuse of trust or deceit. So here there are two alternative forms of behavior. When a person, any person, he has a property, and there's another person, specifically in this offense it's a public official, who is attempting and getting hold of the property of this person, of this what happens to be a victim, by means of abusing of trust. That means that in some way he is earning the credit, is earning the trust of that person. They have some sort of relations built among them, and this unscrupulous public official is using these relations of trust to get hold of the property. And there's other means of committing it. He can also deceive that person, that victim. That's a modus operandi. Condition here is that this person, this perpetrator, is acting outside of his function, so it's not within his function. Remember when I spoke about this issue, and I spoke about it in two different lectures. I spoke about it in a lecture dedicated to public sector corruption. When I spoke about bribery and even abuse of office, I specifically mentioned that the officials must act within the circle of their authority, of their function. What happens if they get out of this circle? And they get out of this circle, usually it falls out of the realm of bribery, and it can be covered. I told you in the previous lecture, that it could be covered by trade in influence, when it could be committed by a public official who is soliciting or taking or accepting promise or offer of a person in order to influence the behavior of another person of authority, or it can be covered by this specific offense of fraud by official who is acting outside of his function. and it should be shown, it's a necessary condition, that this person actually deceived or abused the trust. And deceit, it signifies the situation, it refers to the situation when that person, that public official, he had no, or she had no means of performing performing or implementing his sort of part of the bargain when he's getting something from this victim. I.e., that means, for example, if I give you an example, if there is a ministry, any ministry, and there's a license to be issued by this ministry or an agency, and there are specific people, there's a specific department which is dealing with actual issuing of this license, and there are other departments in this agency, because it could be a big agency, the people who do not actually dealing with the consideration and evaluation of cases and then a subsequent issuing of these licenses, they may deal with something else, like reviewing citizens' complaints and grievances, or dealing with the HR stuff. So if a public official, he is kind of getting this anything this of property of an undue advantage, anything valuable, in exchange and promising that he can sort out this license issue, but in effect he doesn't have any means, it could be it could fall into the qualification as a trade in influence and fraud by official. When it's fraud by official, when it can be fully established in the course of investigation and prosecution that right from the beginning and at the time of committing these illegal actions, there was absolutely no possibility for that person to secure the this outcome of issuing the license. Okay, if there was some kind of relations established between this fraudster public official and the authority issuing license, then it could be a trade in influence. But if there's absolutely no means that that person could have affected, could have obtained that license, then it will probably be a fraud by official, where it is in where it stands in among the different grades of crime. Again, these four categories of there are four different types of fraud. The first one is it doesn't apply to a public official, so it's not the subject matter of our discussion. I just brought it to your attention. When a person, ordinary person, inflicts a damage ranging between 500 manat and 5,000 manat, the liability of a public official starts with the second subsection. An alternative to this, to the liability of public official, would be fraud committed by ordinary people in the premeditated conspiracy, or repeatedly, or in a large, inflicting a larger damage, as you can see, between 5,000 and 50,000 manats. But it's exactly where the liability of public official starts. If a public official commits this offense, then it's considered less serious offense, with the imprisonment up to 7 years. The next one, if it's committed by public official and the damage, here it's again it's covering 178.3. It covers the involvement of a public official if he belongs to an organized criminal group, or if as a result of this fraud damage is inflicted in the range between 50,000 manats and 500,000 manats, i.e. up to 500,000 manat. If a public official commits a fraud by himself or within the organized criminal group, which inflicts the damage up to 500,000 manat or €250,000 as it is right now, then it will be a serious crime with the imprisonment up to 12 years, as you can see from this category. And if public official is committing fraud by himself or in an organized criminal group, or he inflicts damage above 500,000 manat, or as it is nowadays €250,000, then it will be considered especially serious crime with the punishment of imprisonment above 12 years. As you can see, it's quite a harsh punishment. But what can you do if public officials can be unscrupulous sometimes, unfortunately, and if the damage is large, they have to be punished and sanctioned accordingly in line with the requirement of the United Nations Convention on Sanctions, that they have to be dissuasive, proportionate and adequate. We keep repeating these sort of issues in order to make you remember them better. And that brings me to the end of the lecture, repeating you the same slogans. Stay at home, please be optimistic, it will end, I hope, soon, and we everyone hope it will end soon, this curfew. And don't waste your time. Benefit from your studies, whether this discipline or other discipline, or even if you're not a student, just looking at this area or maybe other areas, or just reading books. Thank you for your attention, and don't forget to subscribe to my channel. Thank you.